Italy remains one of the largest economies in the European region, but like most players in the world marketplace, Italy needs foreign direct investment to help stabilize its economic landscape and drive growth. How do those objectives align with the country's oversight of potential investments from outside its borders? Jones Day's Stefano Crosio and Chase Konicki are here to talk about it. I'm Dave Dalton. You're listening to Jones Day Talks. Working primarily out of Jones Day's Milan office, M&A partner Stefano Crosio advises public and private corporate clients and financial investors, especially in the context of cross-border M&A transactions. Pertinent to our discussion today, he has significant experience advising multinationals regarding their investments or divestments in Italy. Jones Day's Chase Konicki advises and represents clients in foreign direct investment matters, including filing CFIUS notices and negotiating mitigation agreements. He is based in Washington, D.C., and assists clients navigate the complex issues associated with international trade and national security matters. Stefano, Chase, thanks for being here today.
Thank you, Dave.
In doing some research, preparing for our conversation today, I ran across some information about the investment climate in Italy. And it turns out this is a very open economy. One survey I found said that Italy is now ranked 10th globally and 4th in the EU in terms of a FDI confidence index. So it appears this is an open economy and that they're actively seeking investment. That said, there are some controls then that we'll talk about this morning, I'm sure. So Stefano, talk about what kind of national FDI system Italy has in place today.
Yeah, thank you, David, for the question. And you're right. I mean, Italy has traditionally been a country that has welcomed foreign investment. And essentially, the main FDI screening system that Italy has in place is a system that is colloquially referred to as the Golden Powers. This is kind of a moniker that indicates an evolution of what originally was referred to as a golden share. That got introduced in the mid-90s during the first wave of Italian privatizations. And essentially, it allowed the government to have disproportionate powers in certain formerly state-owned companies that were being privatized by retaining a nominal equity interest in those companies. Then, later on, the system evolved to what it is right now by essentially moving away from the requirement to hold an interest in the companies to essentially having powers, the government having powers in Italian companies that operate in certain specific industries that are contemplated by the regulations about this FDI screening system.
Okay, let's pick up on that. Which industries are affected by these golden powers?
So even here, originally, the system had, let's say, two main areas of focus. The first one is defense and national security, I would say kind of unsurprisingly. And the second one was kind of a container for three different macro industries. These being energy, communications, and transportation. Okay. Then later on, the system got, let's say, updated fairly recently. In December 2017, the government extended the second basket of industries to include what they refer to as high-tech companies. And this is language that actually the Italian government borrowed almost to the T from the EU regulation that has introduced a screening system, a EU-wide screening system for FDIs. And so it covers sectors such as artificial intelligence, robotics, space and nuclear, financial infrastructures, interestingly enough, and then particularly of interest to many clients, I think, dual-use products, because, this can, of course, affect products that may not necessarily be intuitively subject to this kind of screening. And the last bit of news, and essentially this is really very recent developments because last month the government essentially issued a decree to also specifically make sure that the 5G technology be covered by these golden powers. And so this is kind of the status at this point.
Okay. Go back a second. You talked about dual-use products, was it?
Yes.
Give me an example, please.
So dual-use products are a number of products that, again, may not necessarily make you think that they are, conceived to be used in the context of, for instance, defense and national security. So they are products that can have, let's say, common civil applications, but also be used in the context of defense equipment or apparatus or in the national security segment. One example could be software, for instance, that could be used both for, again, civil use or communication systems, but that can also be used in the context of weaponry or, for instance, military aircraft or Navy ships.
Okay. So this could give the Italian government very broad oversight, I think, when they take a dual-use product kind of position?
Absolutely. This is exactly right, Dave. And these last changes, which, by the way, have not come into effect yet because the government has been delegated to issue essentially secondary regulations to narrow down and specify more in detail the specific type of products that would fall within the scope of this extension of its FDI screening powers has not been issued yet. So, but this should be forthcoming, and when it does, you're absolutely right. This will trigger many more filings.
Interesting. Let's bring in Chase Konicki for a minute. Chase, based on what you've heard so far during this discussion, he mentioned that, well, this is sort of mirroring what the EU is doing. Is anything you've heard this morning surprised you, or is it sounding very familiar, or what's your take so far?
Yeah, I think, good question. I think I'm actually a little bit of both. I'm a little surprised at how familiar all that sounded to me. I mean, It sounds like Italy is essentially in a very similar position to the U.S. from an FDI perspective. I mean, the U.S. has traditionally focused on the same types of industries and products that Stefano laid out, things like the defense products and foreign investments in so-called U.S. critical infrastructure, energy, transportation, and the like. But also, as a result of a statute that was passed in the middle of last year, the U.S. government is also putting higher fences, if you will, around certain types of higher-end technologies that traditionally have not been subject to export controls, stringent export controls, but are nonetheless the types of technologies that the U.S. government and apparently the Italian government have recognized are sensitive to their respective national securities. And these are technologies like artificial intelligence, semiconductor technology. And so the U.S. government, similar to the Italian government, right now is working through and struggling with trying to identify the specific types of, for example, artificial intelligence that it deems to be critical to its national security, which I think is a pretty difficult task. I mean, if you look on any company's website, I mean, they're marketing that they're using AI. So what separates non-sensitive AI from sensitive AI? I don't know that I know the answer to that.
Well, it's another case where I believe, the technology and the science and the advancements are way out in front of our regulators and our rulemaking and our laws. And it's an unenviable position for them to be in. And some of this might be out of an abundance of caution. These kind of broad powers are giving themselves to kind of keep an eye, and maybe you don't blame them. Well, let's talk about what happens with a specific deal. Stefano, talk about reporting requirements. Let's say a deal falls into one of these relevant industries we've been talking about. Are there reporting requirements to the Italian government? And if so, who's responsible for doing the reporting? Is it the buyer or the seller?
Yeah, it's an excellent question, David. The answer to the first part of the question is yes. So the Italian FDI screening system provides for mandatory filing with the Italian government. And in terms of the second part of your question, so who's responsible for it? It depends on the type of deal. So essentially, in a stock deal, the responsible party is the buyer, which has a deadline after signing the agreement and before closing, essentially, to file with the Italian government, was by contrast in an asset deal, the responsible party is the seller, who will be required to file before approval of essentially the corporate resolutions authorizing the deal, be it a merger, spin-off, an asset sale.
Okay. You mentioned a stock deal. Does the transferred stake or percentage of ownership in the company need to be in excess of a certain or set minimum to trigger reporting requirements?
And this is also a very interesting question, and I think the answer is interesting as well, because it depends on which of the two, let's call them baskets that we were talking about before, applies. So in the sector of defense and national security, the thresholds are minimal, meaning if we're talking about an investment in an Italian listed company that operates in those areas, you may be required to file for an investment which is as low as 3%.
Wow.
Yeah, and to some extent, for private companies, it's even worse, meaning that there is no set minimum threshold. So in order to essentially be as cautious as possible, you should file regardless of the size of the investment. Whilst in the second basket, that the threshold there is much higher, and essentially the requirement is a controlling interest.
Okay. All right, so let's say I'm involved in a deal and I don't report. For whatever reasons, I forgot, I'm going to try and sneak this through or whatever. I've got to imagine there's some pretty serious consequences for failing to report this sort of transaction that's covered by these requirements. Stefano, can you talk about what those repercussions might be?
Yeah, and this is something really relevant, especially because given the broadening of the industries that fall within the scope of these powers that we were discussing before, and to your point, Dave, sometimes it may even be kind of a genuine mistake, meaning that a purchaser or a seller don't realize that one of the product lines of the target companies do fall within the scope of application. So they don't file, not because they're trying to get away with it, so to speak, but just because they don't realize it. And the consequences are significant because essentially one consequence that is common regardless of the type of deal the parties are trying to put in place is a monetary fine, which is shaped in a way that is similar to antitrust fines, so it's particularly significant. And it would be the greater of twice the deal value or 1% of global sales in the affected sector. So we may be talking about some serious money here. Wow. And then in terms of consequences on the deal, depending on the type of deal, if it's a stock deal, essentially the voting rights of the stock that gets transferred are suspended, and the acquirer has a requirement to divest the interest within 12 months. Whilst if we're in an asset deal type of situation, then it's, if you will, even worse, meaning that both the resolution authorizing the transaction and the actual contracts implementing it are null and void, which means that anyone without any kind of statute of limitation could bring this up and essentially unwind the transaction.
So the consequences can be severe. This clearly isn't like getting a parking ticket or something. You want to be compliant. You want to do things the right way. Chase Konicki, hearing about the potential consequences of failing to report in Italy, does this come close to what you've heard that goes on in other jurisdictions for these types of penalties?
It is, and I think we've explored a lot of jurisdictions in their FDI regimes, and I think it does vary. But I think those that don't have those types of consequences in place are probably thinking about putting those types of consequences in place. And I think we saw that play out here in the U.S. over the course of the last few months. CFIUS stood up a pilot program back in October that for the first time requires mandatory CFIUS notifications for foreign investments in critical technology companies. And failing to comply with that mandatory notification requirement can subject both parties to a penalty up to the value of the transaction. And so that's the first pilot program we've seen that puts these provisions of the statute in place, these mandatory provisions and the ability to penalize parties. But that's not going to be the last mandatory notifications that we see. As the statute gets rolled out later this year into early next year, other types of transactions, foreign investments in the U.S. also are going to trigger this mandatory notification requirement, and we expect that failing to comply with that requirement will result in penalties.
Absolutely. Well, like I said, it pays to be compliant, I think, because the penalties can be staggering. But let's talk about how it's actually worked so far as transactions and deals have gone down. Stefano, how often has the government exercised these powers up to this point? And have you noticed a concentration in any particular industry or sector?
Yeah, absolutely. And this is a great question to try and put all that we have discussed into some kind of practical perspective, if you will. Let me just preface this by saying that essentially, if you notify a deal and the government wants to exercise their powers, essentially the government can do either one of two things. And the general principle is that the government should act based on principles of proportionality and reasonableness. Mm-hmm. And therefore, let's say that the default consequence, if the government wants to exercise their powers, is imposing conditions on the deal. And the government also has the power to outright veto the transaction, but this should be limited to really exceptional circumstances where the imposition of conditions would not be sufficient to protect essentially the interests of the government. So having said that, over the last 7 years, the government has screened about 120 deals. And it is interesting to note that 60% of the deals that got screened in that time period were screened over the last 2 years. Okay. So this shows a significant uptick in terms of control on the part of the government of pending transactions. And of all those deals that have been screened, the government has exercised their powers in 14% of the filings, mostly, consistently with what I was saying before, by imposing conditions, and only in one case has the government vetoed the transaction. And let's say that 70% of the cases where the government decided to take action were in the segment of defense and national security, as was that only case in which the government vetoed the deal.
Yeah, I'm not surprised. In fact, that was going to be my next question. It's like, I got to know. Tell me which one. And I think it was probably defense-oriented. So awesome. All right, let's wrap it up with this. Let's say we all want to do the right things. We want to remain compliant. How does a would-be investor ensure compliance with Italian FDI regs and avoid, getting blindsided or surprised while they're trying to get a deal done? What do you recommend, Stefano?
Well, essentially, my recommendation is, number one, in this climate, not to take anything for granted, meaning that the old categories to some extent no longer apply because of these latest extensions, essentially to encompass a much broader variety of products. So in our view, essentially, diligence is key. And my recommendation would be for a proposed purchaser to kind of approach FDI screening in the same way as it's done for antitrust, for instance. Mm-hmm. So by facing this upfront in the diligence process and by essentially correlating the output of the business diligence, which focuses on essentially the production lines of the target and the types of products that get manufactured, mm-hmm. with the legal diligence in such a way that if there is a risk that some of the products may fall in one of the affected areas, this gets flagged upfront, and then the parties will decide how to proceed from there.
Real good, real good. Chase Konecki, this could be a heavy lift for a company, right? In-house counsel, or if they're bringing an outside counsel, whatever. This is a lot to worry about, isn't it?
It is, and I think we've been talking about all these different jurisdictions, and so it's not only having to worry about if the company's headquartered in the U.S., for example, I mean, that rings a U.S. bell, and you need to think about CFIUS. Or if the target company is headquartered in Italy, that also would probably trigger, you to think about the Italian FDI regime. But it's also not just where these companies are headquartered. You have to take a broader approach as to where that target company has operations outside of its headquartered country. For example, a company that's headquartered in Italy may have operations in Germany and France and doing the same types of activities they're doing in Italy and those other countries, which, of course, in that scenario, you need to think about the other FDI regimes in those other countries. And so it really, I echo what Stefano said, that you really need to map this out at the beginning of a deal and figure out where the touch points are and where the real risks are.
This is no time to cut corners, that's for certain. Hey, gentlemen, learned a lot, as always. Stefano, Chase, thank you so much for being here today. Let's do this again soon. We'll watch developments, and as there's more to report, we'll have you guys back on.
Thanks, Dave.
Great.
Take care. Have a good day. Thanks. You can find information on Jones Day's M&A and government regulation practices at jonesday.com. You can find complete bios for Stefano and Chase there, too. Subscribe to Jones Day Talks on Apple Podcasts, Android, Google Play, and Stitcher. And while you're there, check out some of our previous podcasts on foreign direct investment. As always, we thank you for listening to Jones Day Talks. I'm Dave Dalton. We'll talk to you next time.
Thank you for listening to Jones Day Talks. Comments heard on Jones Day Talks should not be construed as legal advice regarding any specific facts or circumstances. The opinions expressed on Jones Day Talks are those of lawyers appearing on the program and do not necessarily reflect those of the firm. For more information, please visit jonesday.com.